Okay, we can. So we're gonna have to. I don't know what happened to that other stream. It like disappeared. It wasn't even there. I will have to redo the description for everybody, just so you know. We will redo the description, and please check all the links in the description to Bear's channel and everything. So here we are. Much better. All right, that's good.
Good.
And hopefully people will give a couple of seconds. What's up, Anna Banana? So as we get started here, this is our first featured member of our new private Telegram community, the Lion's Den. This is Bear Arms from No Duty to Submit YouTube channel. If you guys are not following No Duty to Submit, you got to go over there. You could watch all his videos probably within 2 hours. Most of them are like 7 to 15 minutes long, and he covers taxes and statutory construction of these terms with taxes and the right to bear arms. So that's what he focuses on and specializes in. And he also has a lawsuit that we're going to get into here in Massachusetts. This is a federal lawsuit. And why don't you take it from there and tell us about this?
Sure, yeah. So we're going to talk about how Massachusetts converts our right to keep and bear arms into an entitlement and then licenses it and sells it back to us for a fee. We're going to go over the mechanism, the legal mechanism by which they do it, the words that they use, and how they're actually constitutional. That is constitutional as written by the legislature. That doesn't mean it's constitutional as applied, and that's an important distinction because legislation is to be construed and applied in harmony with, and not to thwart the purpose of the Constitution. That's Phelps versus the United States Supreme Court case. And that's also common sense. So basically, what the legislature has done is they have very, very carefully crafted their words using custom definitions to remain scrupulously constitutional. And yet they have constructed a bait and switch deception that's intended to mislead the public and ordinary law enforcement officers to misconstrue and to misapply their statutes. See what I mean? That's how they do it.
Can you repeat that last part real quick? Because you broke up a little bit.
Okay. So the legislature, they have constructed a bait and switch deception that's intended to mislead the ordinary public and the ordinary law enforcement officer to misconstrue and misapply the legislated statutes as they are written. Okay, so basically they're giving dual meanings for words, and they're not telling us what they mean, and they're allowing us to presume what the words mean and then to act upon them. Let me give you an example. So you know that you need a license to carry firearms in Massachusetts, right? And that's a perfectly true statement, and also happens to be a constitutional statement. But what they don't tell you is that the license to carry firearms mean firearms that are specifically defined in the law. Okay. Now they call firearms as, and I quote, firearms as defined in section 121 of chapter 140. And that includes items in retail sale or the repair shop of a gunsmith. If you look up section 122 of chapter 140, or it means a firearm that's carried in the performance of duties or for hire by police officers, by sheriff's deputies, by private security guards, armored truck drivers, private detectives, investigators, watchmen, guards, etc. Okay, and that's Mass General Laws 6E, Section 1, Chapter 41, Section 98, Chapter 147, Section 8A, comma 29, and 29A. And also, they also mean firearms that are stolen. Okay, if you have a stolen gun, that's technically a firearm. You see what I'm saying? Or a firearm that's a weapon, or a weapon used in a violent crime or a felony. That's under Chapter 265, Section 58, 15E, 15F, and 18B. Or if you got a firearm that's got a defaced serial number, that is technically a firearm. If you defaced a serial number on a gun, that's a firearm. Okay? And that's Mass General Laws 269, Section 11A, B, and C. Or a firearm that's discharged within 500 feet of a building, that's a firearm. Or a firearm that's used in a hijacking, a disruption of school, public building, or transportation, under Mass General Laws 269, Section 12D, 12F, or 14. Those are firearms. Again, firearms in a crime. And the last type of firearms that the Massachusetts General Laws defines is the firearm that you're not supposed to buy with welfare assistance money. So in other words, if you get welfare money, you can't take your EBT card and go to the gun store and buy a firearm, because by that definition, it's a firearm that you're not allowed to have. So these firearms are to be distinguished from other Massachusetts general laws. Okay, one of which is Mass General Laws 131, Section 78, which talks about the protection of property by landowners. In other words, farmers and agricultural owners who have to shoot like a coyote to defend their flock, right? Shoot birds in order to defend their crops and so forth. And that's described in Chapter 131, Section 66 and 67 to include a shotgun, any rifle, any revolver, or pistol. Okay, those are not firearms. And also, Chapter 131, Section 37 talks about firearms that are used to protect your farm, basically. Other chapters, for example, 149, Section 177, talks about the arms in the defense of his property. So you can defend your property with arms. And if you're employed at a job, you can also defend that property with your arms. And then the most important thing is there are two laws in Massachusetts that go all the way back to 1786 with text that's very, very similarly written. And that's Mass General Laws, Chapter 62C, as in Charlie, 55A, and Mass General Laws, Chapter 60, 24, Section 24. And if you read those laws, you'll say that you have a right, or that you can keep, along with your fuel, your provisions, your furniture, your personal effects, your beasts for the plow, your livestock, your tools for the trade, your books, and your arms for personal use, and your military arms, uniform, and equipment. That goes all the way back to 1786. Those are the arms that are described in the Constitution, that are arms to keep and bear. Okay, they're
For
not
personal use.
for personal use, and also for the common defense, right? Because
And so if I'm understanding this correctly, a firearm is an arm, but an arm is not a firearm.
you're absolutely correct. So if you go to my channel, you'll see a video called "My Glock is not a firearm." Okay, that's a very important concept in law to understand the Venn diagram relationship of things. So in the world that we live in, all firearms are arms. Just like all pine trees are trees, all goldfish are fish, right? All cops are public officers, but not all public officers are cops. Not all fish are goldfish. Not all trees are pine trees. Therefore, not all firearms are arms, right? Now, the Constitution divides all arms into two groups. The first group is the ones that people keep and bear. Those are the ones that are constitutionally protected. And guess what's in the other group? It's everything else. Everything else that the government has control over, and those generally include three categories: firearms that belong to the government, firearms that are in commerce or in some sort of professional role, and then firearms that are in the commission of a crime, that's evidence to a crime, right? So if you don't have those three types of firearms, what you have is an arm for personal use, and that's guaranteed under the Constitution. Now,
Cannot be regulated.
yeah, right. Those things cannot be regulated. Arms for personal use and arms that you keep and bear cannot be regulated. Now, this is important because under the law, that's Mass General Laws 277, Section 37, it says, for the purposes of an indictment, if certain words and phrases are defined by the law, then they must be used according to their legal meaning. And according to the Supreme Court in Steinberg versus Carhart, all right, that's a 2000-year case, 530 U.S. 914. It says, when a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. So what I have right here, it might look like a firearm, right? But it's actually an arm for personal use, according to the way that it's defined.
So what about so a federally licensed firearms dealer?
Yes.
If you need a license to purchase from them, a license to carry just to purchase from them, but you do not need a license to purchase or make your own firearms.
Okay, so when you use the word purchase, that's a specific entitlement under Chapter 140, Section 131, where it says a license shall entitle the holder thereof to purchase, borrow, rent, carry, and possess firearms. That's what it says. So purchase is a commercial activity. So is manufacturing. That's a commercial activity. And when you use those terms, you are subject to that law, right? Because you've just contracted with that statute. However,
so what would be the proper term?
The proper term is the word acquire, and you get
Acquire.
that Constitution. People have the right to acquire property, according to the Massachusetts Constitution. You have the right to keep and bear arms. That means to have it, and you have the right to acquire arms. Now, if you look at D.C. versus Heller, that's District of Columbia versus Heller, the Supreme Court actually says, if you Google it, it'll say that when the militia was called into service, the men were called and they were expected to bring arms supplied by themselves. Look up those three words, supplied by themselves. Okay? Just word search the document for DC versus Heller, and you will see that's where the people are given, or not given, but that's where we have our right to have our own arms. So if you're making an arm from a piece of wood and a piece of metal that you put together, okay, and you didn't go through commerce, and especially if you didn't cross state lines, no federal law applies to you. In fact, no state law applies to you either. Does that make sense?
Yeah. So I would say rule number one: never use the term firearm,
right,
unless you are someone who has a license to carry for a commercial purpose.
right.
And then so you're keeping and you're acquiring and keeping arms for personal use.
Personal use. And you are not carrying a firearm, because that's the other word they like to use. All right. So we always say, hey, are you carrying concealed? What do you open carry? Whatever. Those words are the words that big media wants to put in your brain so you get yourself into trouble. Stay away from those words. Use the Constitution as a dictionary. It doesn't say you get to carry a firearm. It says you get to bear arms, right? So now let's look at the Constitution and read what it means to carry. So I want everybody to go to the Mass Constitution, right? Do Control F for a word search, and then search the word carry. And you will see it means to carry out legal obligations, to carry out a law into effect, to carry out the powers and duties of public offices, to carry out the new Constitution into effect, and to ascertain and to carry out the will of the people. Do you understand what the word carry means? How about the U.S. Constitution? It says Congress shall have the power to make all laws for whatever the foregoing, and to carry into execution the foregoing powers. Right? These are consistent. These are consistent ideas. Carry means to carry on the duties and functions of public offices. See Mass General Laws 21A, Section 2, and a whole bunch of others. Carry may mean to carry on the business, like I'm carrying on the business of an FFL, or a carry on the business of a gunsmith, for which I need a license. Carry means the powers and duties of police officers. Look at Chapter 41, Section 98, powers and duties. To carry weapons, right? Carry means to carry firearms in the performance of duties by corrections officers, parole officers, penal institution officers. Again, Chapter 47, Section 8A. Carry means to carry in the performance of duties by watchmen, guards, private patrolmen, detectives, or investigators or other persons licensed to protect persons or property for hire. Okay, look at Chapter 147, Section 22, and Section 25. So carry is a duty. Don't be carrying anything as an entitlement without the proper contract, without the proper license, right? But there is no such thing as a license to bear arms. In all 50 states in the United States, have you ever heard of a license to bear arms?
No, doesn't exist. It can't.
It
It
doesn't
can't.
exist.
Can't be.
It can't be. In fact, Murdoch versus Pennsylvania says the license, no state shall impose a license on the exercise of a constitutional right. No state. Murdoch versus Pennsylvania, 1943, right? And you can look that up. By the way, the other meaning of carry is what a carrier does. For example, Mass General Laws 266, Section 38 says, carry means the entitled activities of carriers engaged in business, or private bus carriers in the chapter 161A, public and private carriers, motor carriers, contract carriers, common carriers, interstate carriers, agricultural carriers, carriers of mail, and public air carriers. Those are those who transport and carry things and property and persons for hire. Just look up the word transportation. Transportation means the removal of goods and persons for hire by a carrier. Okay? So don't be carrying things unless you're being paid.
So somebody in the chat said something that I wanted to touch on about Black's Law, the importance of Black's Law Dictionary, and that is 100%. He says, Johnny V, what's up? They know their language, and it's a spell book. And I say that all the time. This is spelling, right? It's spell casting, and when you incant the words of the spell, you become bewitched by that spell. And so what we're trying to do here is teach people the importance of being articulate, choosing your words carefully, and not incanting the black magic spell.
Correct.
Right? We want to incant the proper terms and words and cast our own spell that preserves our rights.
Right. And the way we do that is we use the Constitution as a dictionary. That is the dictionary. If you fail to invoke the terms of the Constitution, don't expect it to protect you. You understand? So look, I got 4 cases here I want to go through real carefully. It's very important. The Constitution is a dictionary, and I'm going to tell you where it shows, where the law says that. All right. So first case, Williams versus the United States, 289 U.S. 553, 1933. In expounding the Constitution, every word must have its due force and appropriate meaning, and no word is regarded as unnecessarily used or needlessly added. Okay, South Carolina versus the United States in 1905. The Constitution is a written instrument. As such, its meaning does not alter. That which it meant when adopted, it means today. Okay? And then finally, or not finally, but there's a couple more, but words must be used with a gloss of the experience of those who framed them. And words, that are words in the Constitution, would receive the significance of the experience to which they were addressed, a significance not to be found in the dictionary. See, United States versus Rabinovitz, 339 U.S., page 56, 1950. So as early as late as 1950, this is good law, right? And it's basically saying you can't use a dictionary if you're trying to define what the words are in the Constitution. What does that make the Constitution then? It makes the
A dictionary.
Constitution the dictionary, right? Now let's
In
go.
this, yeah. Yep.
Correct. So how do we know this? Well, further on we read, Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution, says Perry versus the United States, 294 U.S. 330 in 1935. And then finally, here's a key one here. Congress cannot redefine the terms in the Constitution because the Constitution alone is from where it derives its power to legislate in the first place. See Eisner versus Macomber, 252 U.S. 186 or 189 from 1920. See
So
what
let
I'm
me, yes, I do. And let me touch on this real quick about the Lysander Spooner quote that Anna Banana and a lot of libertarians like to throw it around that, whether the Constitution is really one thing or another, it has it has either allowed such a government as we have had or has been powerless to prevent it. In either case, it's unfit to exist. And I'm going to push back on that a little bit and dispute it in that it's not the Constitution. That's like saying the Bible is unfit to exist because men have failed to live in accordance with the principles of the Bible.
Yeah.
So it's men that have failed. The Constitution, an inanimate object, cannot do anything, right? So it can't fail and it can't succeed. It's only men and women who can embody it and be the Constitution, have a Constitution that they live and hold others accountable to. It's up to us to protect it and enforce it. And it's these word games that we're focusing on here is how they have done this little shell game end around to manipulate us and to trick us into incanting their spells, right? That are outside of the Constitution. So if you don't do that, don't play their game, then it's very important this word game in the spell casting here.
Yeah. So like if we look at the Bible, which by the way is an excellent example that you just gave, because the Bible is to mankind as the Constitution is to the United States of America. And in the Bible, in Hosea 4:6, it says, "My people are destroyed for a lack of knowledge. Because thou hast rejected knowledge, I reject thee. That thou shalt be no priest to me, and seeing thou hast forgotten the law of thy God, I will also forget thy children." So if you don't read the Constitution, don't criticize the Constitution. If you don't learn to use it to your advantage, don't say that it didn't work in court. You have to invoke the terms of the Constitution and stick it to them and reject their statutory contracts. And that's the only way we can go about it, really. That's that's what
I
we can
mean,
do.
it reminds. I'm not even a Christian, but it's like the Tower of Babel. All this statutory law is like taking the Constitution, smashing it, and flipping these pieces around and calling them something else to do this, like you said, the bait and switch.
Yes, yes. Um, so okay, so basically going back to the license to carry, there are those three words, right? License to carry firearms. So license, firearms, and carry. We kind of went over the words firearms and license and carry. Now let's go to the word license. So if you go to you go to the law to read the law, right? Mass General Laws, chapter 140, 131. A license shall entitle the holder thereof to purchase, possess, and carry firearms. That's what it says. Did it say it will give you the right to bear arms? No, it says entitle. Entitle. So that's why it's an entitlement. And who gives the license? Well, in Massachusetts, it's the Executive Office of Public Safety and Security. And those guys are engaged in the are vested with the power to give you that entitlement. And what's their subject matter jurisdiction? It says it right in their name. Public safety and security. So when they give you that license, it's for the purpose of you carrying a firearm to ensure the public safety and security. That's what the license is for. Okay.
To
Now,
protect others,
to protect others, you don't need a
which
license.
goes against the Constitution.
Well, I mean, it's a delegated power from we the people, because you have a right to protect somebody who's being hurt, and therefore you have the right to delegate that power to the government to prevent that crime from happening. Okay, so for example, in Massachusetts and in a lot of states, there are three basic things that you have to do in order to get the license to carry. The first thing is you got to get a background check, right? And if you go to their codes again, Code of Massachusetts Regulations, number 803, section 2.01, it tells you right there what it's for. It says the purpose and scope. Okay, I don't make this up. This is what they say. The purpose of scope is for the purpose of evaluating applicants for employment, volunteer opportunities, and professional licensing. Where does it say that their license is for to keep and bear arms or to exercise a personal, individual, and private right? It doesn't say that, does it?
No.
The second thing you have to do is got to get your fingers printed. So in order to get your fingers printed, you read the law, the authorization, right? That's Mass General Laws, Chapter 6, Section 172B. And it says it requires applicants for licenses in specified occupations to submit a set of fingerprints. Does it say you need to submit a set of fingerprints to exercise a constitutional right? No, it's for a specified occupation. Let me give you an example. If you want to take care of children as a child care specialist, you better go get yourself a background check and fingerprints. Because if you don't, who's to say you're not a child molester? I want to know as a parent, right? And if you don't get that license, I want you in jail because you're really violating the law, right? So the fingerprint requirement is very specific. It's for specified occupations. And if you're going to carry a gun in the performance of a duty to serve the public safety and security, you better believe I want you to have a license, because I want you to be not a felon and not somebody I can that can be that's not trustworthy. Right? And then the third requirement for getting a license in Massachusetts is the $100 fee. And guess who you pay the $100 fee to? You pay it to the licensing authority. And the licensing authority is one that's explicitly defined at Chapter 6, Section 172N as in November, where the licensing authority is 1. With the authority to impose an occupational fee or a licensing requirement on a profession. Can that be more clear? Can it be more clear? When you give the $100 to the licensing authority, you are giving them an occupational fee or a licensing requirement on a profession. This is
So,
yeah.
real quick, because this is relevant. So, Doormaster, we're gonna correct you here. We don't have a right to carry. We have a right to bear arms, to keep and bear arms. We do not have a right to carry firearms. Carrying firearms is something that's done for a job in commerce, as we've been trying to highlight here. And so by incanting the word carry or firearm, you are delving into statutory law that has to do with commerce and having a license to carry for a job or a profession or for volunteering, right? In the right to keep and bear for personal use to keep and bear arms is distinct from carrying firearms. So that's where we really got to try to correct our language here, and use it appropriately, because this is satanic. Yes, Anna Banana, this is satanic spell casting, and they invert all these things and create these little parallel illusions that they get us to consent to when we invoke these terms.
Right. So let's make it very clear, and thank you for that, Frank. Let's make it very clear. The word carry is a public entitlement. It's licensed by the Office of Public Safety and Security. It's an entitlement. It says those are the words that they use. Okay. The word bear is an individual right secured by the Constitution. And if you look up the word individual right, this individual right is described in Heller versus, or rather, DC versus Heller, and Chicago versus McDonald versus the city of Chicago. It's an individual right that applies to the people. Okay, so that's a one thing is in the private, and the other thing is in the public. It's got to be 100% clear.
It seems it's kind of confusing, because most people, and I would say, well, what's the difference? These are just different words that you're using for the same thing. Well, no, the words define the the meaning of the thing. So like you said, pine trees are trees, but not all trees are pine trees. So again, all firearms are arms, but not all arms are our arms are not firearms,
Right.
by definition.
By definition, the arms that people keep and bear are not statutory firearms.
According to the dictionary of the Constitution.
The dictionary of the Constitution, right, and the dictionary of the statute, because those are two different things. And they are divided by the division of the Constitution. That's where the Constitution ends, and that's where you contract away your rights.
So they've basically created an entirely new lexicon or dictionary to regulate things, and making people think that this is the only game in town. Everything's a firearm. Everyone needs a license. But that's not how it works. And I mean, it's the same thing for the right to travel, which
Right.
we're working on as well.
Correct. All right. So I guess that brings us to the second part. That now that we define those three terms, license, firearms, and now we're going to talk about how they have used this constructive fraud and how they've misapplied it to the right of the people to keep and bear arms, so that they
Hold
can.
on, you broke up a little bit there.
Okay. So now we're going to talk about how the government uses those three words to illegally prosecute the lawful exercise of a constitutional right. Okay. So first of all, let's look at only situations that are lawful situations, meaning one that does not include a injured party. If someone's out there robbing a bank, that's not keeping and bearing arms, right? Are you okay there, Frank? You're like blurring in and out. Frank, can you hear me? You speak.
I don't know what's going on. I don't know if it's my stream or what, but can you hear me?
No, I can. Yeah, you are blurring in and out. But okay, you tell me if I can hear myself. Well, I mean, can see myself fine. Anyway, so let's talk about how the government is illegally prosecuting the average law-abiding citizen exercising his constitutional right. For example, a guy in Massachusetts, a guy in New Hampshire bearing arms legally and lawfully walks across the border. Now, all of a sudden, he's a statutory felon. He's facing like 18 months plus in jail, up to 2.5 years in the federal, not in the state prison. How does that happen? Well, we already told you it's a professional license. So if you have a right to do something or an entitlement to do something in one state, which is a professional entitlement, that of carrying a firearm, and you cross the state border, then that right no longer, or that entitlement no longer exists. But the constitutional right to keep and bear arms do not stop at state borders, right? So here's the fraud that we're dealing with. The district attorney is only the prosecutor. He's not the victim. The victim of the statutory or regulatory offense is the party that's claiming a breach of contract. And so, who's the party that has the contract and is alleging a breach? Well, that's the Executive Office of Public Safety and Security, which is the office that does the administration and enforcement of the firearms licensing. They are the ones that have the original subject matter jurisdiction of what it means to carry a firearm and what their license entails. And they also are the only ones that know the difference between carrying a firearm and bearing arms, correct? So, when a man is brought to trial, does the Executive Office of Public Safety and Security show up? They don't, right? It's only the prosecutor, and he's saying, hey, you carrying a gun, you didn't have a license for it, even though you're perfectly legal and you stepped 10 feet into Massachusetts from New Hampshire, now you're a felon, right? But where's the Executive Office of Public Safety and Security? They're not there. So if they are not there, then they are the Executive Office of Public Safety and Security, and I'll call it EOPS from now, is in violation of the administration, namely Chapter A, Section 1, where it says, if there's a legal right in dispute, the agency shall institute or recommend institution of proceedings in a court. Did EOPS institute or recommend institution of proceedings in a court? Of course not. It's just the court and the prosecutor there. There is no EOPS going on there. Okay? And because the party that's claiming a breach of licensing of the licensing contract is not present, the court does not have competent jurisdiction over the subject matter that's being adjudicated. Okay? So that makes the court have to make a determination for and by itself whether this object is a firearm and whether or not you were carrying it. And they're doing it in the absence of the regulatory body that's assigned to regulate and administer and enforce that particular license. And so what they're doing is they are in violation of the Declaratory Judgment Act. That's Mass General Laws 231A, Section 8. That it says, in any proceeding which involves the validity of a license granted by the Commonwealth, the agency granting the license shall be made a party and shall be entitled to be heard. Now, when the judge has to exercise that fact-finding and regulatory function of that executive branch, then we've just lost the impartial interpretation of the laws and the administration of justice, and he's also violated the constitutional doctrine for the separation of powers. That's Article 29 and Article 30 of the Massachusetts Constitution. You see how many laws they're breaking? They're breaking laws, right? Okay. So, Frank, are you able to see and hear everything well?
I'm not sure if it's just me. Is it choppy for other people? Can somebody let me know if they could hear Bear? It's choppy on my end, and I don't know if I'm choppy right now or not.
I don't know. Can the audience maybe
If somebody can say something in the chat, that'd be great. If you were able to hear Bear without, I heard some chopping and stuff, but it's probably my Wi-Fi. Both sound fine to me. Okay, cool. So
All
it's
right, good.
just
All right.
excellent.
Good. All right. So you might want to ask if there are laws that they're getting around all these things? Well, it's simple, because they made it complicated enough that the average defendant don't know that they're actually in an adjudicatory proceeding. Okay, that is hold on. It says audio sounds good, but faint. Okay, all right. As long as
So
we're
yeah, it's
good.
my Wi-Fi. I apologize, everybody.
All right. So basically, the average defendant doesn't know that they're not in a court of law. The average defendant doesn't know that they're in an adjudicatory proceeding, which is an administrative function of the Executive Office of Public Safety and Security. And so they're not calling them out, basically. And furthermore, they're not rebutting the terms of art that's used in the prosecution. The prosecutor is saying, hey, we're charging you with bearing arms. You get to go to prison for bearing arms. Right? They can't say that because that's obviously illegal. What do they say? They said, we're charging you for not having a license to carry a firearm. Right? And that's something that if you don't object to, then you are presumed to consent. Okay? So is everybody getting this? I can go. I'm gonna want to go through a list of violations that these guys are violating. First of all, as we said, the court lacks subject matter jurisdiction because the executive branch that licenses the subject matter of firearms is not present. The court is therefore acting ultra vires, meaning out beyond their powers, and that violation of their jurisdiction is the only thing that judges can be lawfully sued for because they're acting beyond their jurisdiction. That's number two. Because they are deceiving the jury, who like average people have no clue about the meaning and distinction between carrying a firearm in the performance of duties versus bearing arms for personal use. The prosecutor, as an officer of the court, is engaged in a crime, and that crime is called fraud upon the court. Fraud upon the court is when a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially adjudicate a matter by improperly influencing the trier of fact. This crime is directed at the judicial machinery itself. That is an intentionally false and willful blindness to the truth or reckless disregard for the truth. You could look up Herring versus the United States and Gimnaniak versus Petrowski. Those are from 1993 and 2005. But look up fraud upon the court. That's a very important thing. So the next thing that they're guilty of, as I was saying, is the violation of Article 29, which requires an impartial interpretation of the laws and administration of justice. And that happened when the court had to perform the fact-finding mission of the executive agency. Again, that's also a violation of Article 30, which is the separation of powers doctrine. Finally, the EOPS, and that's not the prosecutor, by the way. That's the absentee executive office. They are violating what's known as the major questions doctrine, and that's outlined in West Virginia versus EPA. Excuse me. The major questions doctrine is that given both separation powers principles and a practical understanding of legislative intent, the agency must point to clear congressional authorization for the authority it claims. And the fact is, EOPS has absolutely no authority to license or regulate the right of the people to keep and bear arms for themselves. And they have no more power than the state medical board can regulate your right to, let's say, perform surgery on yourself, or the dental board's right to regulate your own teeth, or the tax accounting board's right to regulate how you file your own taxes, or the attorney, the bar association's right to to tell you what to do as a pro se litigant. Okay, those regulations only apply to those professionals, and you are bearing arms for yourself. You're not a professional. Again, the license is a professional license. It does not apply to you in any way whatsoever. So the next thing it violates is the due process guarantee. Allows every man to find his safety and his to have his issues adjudicated in a court of law, not an administrative process before a licensing board. Okay. And again, because EOPS wasn't there, no one can tell you and fully and plainly, substantially and formally inform you of the crime or offense to satisfy the requirements of Article 12. So you're not being told what the difference is between carrying a firearm and bearing arms. So that's a due process violation, as is violation of Article 13, which says the verification of facts is very important in criminal prosecutions, and you have a right to the verification of facts. Can you verify that I was carrying a firearm and not bearing arms for my personal use? Allowed to verify that, so that's a violation. All right, and that's all before they get to the actual meat and potatoes of the Second Amendment right to keep and bear arms. These are all due process rights, not substantive rights. Okay, there's a couple more due process rights or constitutional rights. For example, we're going to talk about Article 5 and Article 6 of the Massachusetts Constitution. The first one is about the deprivation of powers, and the second one is a violation of privileges that arise from services rendered to the public. Let me explain that. The EOPS is supposed to license professionals of public safety and security officers and employees who carry firearms for your safety, for the public safety and security, as a member of the public. They're not there to license your original right to keep and bear arms for your individual and private personal use. Okay? So the privileges that you obtain, it's one that arises from the service rendered to the public, right there in Article 6 of the Constitution. And then furthermore, because they're intentionally misapplying and against all people and charging a fee and threatening the population with prosecution and jail, that's contrary to Article 7, right? Because Article 7 says government is instituted for the common good, for the protection, safety, and prosperity and happiness of the people, not for profit, honor, or private interest of that particular agency for themselves, who's collecting about $6 million a year on renewal fees and application fees and all the other fees. Correct? Am I right?
I'm with you, bro. 100. So we have a question from Doormaster 77. He says, so why do we need a state issued license to carry? Keeps disappearing. If we have a constitutional right to bear arms, and correct me if I'm wrong, if I'm following here, we don't need a license to carry unless you need it to perform a job that requires said license. You cannot you cannot create a license for a natural right that's enshrined by the Constitution, because that's the other thing. The Constitution doesn't grant us any rights. It preserves and recognizes pre-existing natural rights, the right to self-defense, right? So we don't need a license, and they cannot create a license for the right to keep and bear arms, but they can create a license to carry for professionals. And so that's where we need to sort out this situation.
The hardest thing I've been able that is hard to convince people is that the word carry means to carry out the performance of a duty. Carry means to carry for a hire. Carry means to carry for a reward. Carry means to carry on the functions of a public office. It is not the verb, carry. I'm not carrying this in my hand. I'm bearing it in my hand. I'm holding it in my hand. I'm keeping it in my hand. I have it in my hand, but I'm not carrying it unless I'm carrying it for hire. I'm carrying it for commerce. I'm carrying it for a fee.
Well, you can't carry unless you have a license.
So you definitely need a license to carry. The question is, what is carry? Carry means an entitlement, a public entitlement to serve the public safety and security. Once you understand that in the context of a constitution and the statutes, then you'll realize you're not carrying. So if you're not carrying, why are you getting a license to carry? Right? And I'll tell you why.
They want the revenue
I'll tell
and the
you why.
control.
It's because they have convinced enough people who are sleepy enough, who are not awake, who are not looking and studying, and who are not vigilant to have the false belief and the absurd belief that you need a license to have an arm. And all those people, because there are so many of them, they are oppressing those who are actually thinking and studying. And that's how tyranny works. Because, there's a guy named Wilhelm von Goethe. He's a famous German philosopher, right? And his thing is, he said something like along the lines of, they're more fearful than ignorance in action. In other words, if the people are stupid and sleepy and not vigilant, again, for a lack of knowledge, my people perish. We lose our rights. We lose the Constitution. We lose the Republic. That we're supposed to pass on to the next generation if we lose the knowledge of what those words mean and to carry it forth to the next generation. Yeah, I don't know. I'm just ranting now.
Yeah, no. So we've talked about the situation here in New Hampshire where I'm arguing RSA 607A. This is for the Uniform Act on Status of Convicted Persons, which is what defines what is and what is not a felon.
Right.
And so a felon is someone who is incarcerated, has restitution to pay, or suspended time. But if
Correct.
you've served prison time and got out and you don't have any restitution and you don't have any suspended time, then you're no longer a felon. You are a convicted person who now, by statute, gets all your civil rights or all your core constitutional rights back just by virtue of statute. So that's another thing that we're working on here in New Hampshire, and I'm gonna, be trying to do this declaratory judgment thing like you are in Massachusetts. And if people don't know, Bear, the whole point of this is he has a ongoing controversy in federal court in Massachusetts. I am on the lawsuit. I jumped on this thing, and if anybody else wants to jump on it, please contact Bear. I have to re-add all his contacts in the description after this, but check shortly after the stream for the description for all those links.
Right. Now, I did prepare a little bit about that, about a convicted felon and so forth. So let me just say that under historical conditions, once you've served your time and you're let go, you're just about as safe as you were before. If you're safe enough to be let out in the streets, you're safe enough to have arms, and you're safe enough to have all your rights restored. The law in this regard is at this time under litigation, and it's incomplete. And there are two cases that are going to the Supreme Court right now regarding whether convicts or nonviolent felons may get their arms back. And those two cases are Range versus Attorney General of the United States out of the Third Circuit, and versus, like I said before, that all sane men, we're not talking about crazies here, okay? crazy people shouldn't have guns. We get that. But all sane men have a right to defend himself against bodily harm. And if they've served their time, then they should be deemed safe enough to be released and should get all their rights back. In fact, there's no law they can't. I'll tell you why. There is this right to keep and bear arms. Whether or not you're a felon is not to be subject to a vote, and it does not depend on the outcome of any election or legislation. And I'll tell you where it says that. I'm going to read to you West Virginia State Board of Education versus Barnett, 319 U.S. 624 from 1943. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials. That's the whole point behind a Republican form of government that we are endowed with under Article 4 of the Constitution. Every man is a sovereign. You don't get to vote as how I live my life unless the thing I do somehow infringes upon your rights. Okay, so even if somebody who's been convicted of a crime, I don't get to say, well, he's been convicted of a crime 10 years ago, so he doesn't have the right to defend himself against some asshole who's invading his house. Okay, so you can also see that in things like Miranda versus Arizona, where it says where rights in the Constitution are concerned, there shall be no making or legislation which would abrogate them. It's black and white law. Constitutional rights cannot be legislated. Now, in the sense that in the current situation where convicted felons, former felons, have a de facto situation of being disarmed, here's what I would consider to be right. If you have been disarmed, that means you have the ability to call on protection. After all, you have the right to be treated equally under the law, correct? Even if you were a former prisoner or convict, you still have a right to life. And if you have that right to life, then you can delegate that power to the police officer. And since the police officer is not holding you for anything, then maybe we should delegate that power to the state, which is instituted for the common good, for the protection, safety, and prosperity of and happiness of the people, and have an officer assigned to you on a 24/7 basis. Because apparently you can't defend yourself. So let's get an officer to so that you can delegate your right to him, so he can defend you, protect you.
Why not?
Why not?
Right.
So that yeah, exactly.
So real quick, Brad did say, he mentioned the legislature of New Hampshire enacted 159.3 alongside, but so the 159.3 is for felons. That would be a convicted person. 607A defines what is and is not a felon. It doesn't say that explicitly, but it's called the Uniform Act on Status of Convicted Persons. At some point, just because you were convicted in the past does not mean it's 607A3, rights retained. You retain and you get all your rights back that you were deprived of during the time that you are or were a felon, right? So there's this bait and switch thing happening there again, where you have to understand when you're no longer considered a felon anymore by the state statute. And for me, I've served all my time, and there's nothing in RSA 607A that says you get all your rights back except the right to bear arms or carry a firearm. And they could put the carry a firearm part in there legally, right? You wouldn't be able to carry a firearm couldn't get a license for it, but you still have the right to keep and bear arms without a license. You won't be able to get a job with it, right? I wouldn't be
Right.
able to become a cop. I wouldn't be able to become a security guard or something like that. But I still have the right to personal use to keep and bear.
Exactly, because that is a professional entitlement. The professional board can do whatever they want to legislate it. For example, if you're adjudicated to be a, I don't know, a drunk or drunk driver and you apply for a medical license, they can say no, right? They can say no. But that doesn't take away your right to, I don't know, set your own fracture, suture your own laceration, or take medications for yourself. There's a license for.
I mean, you could also argue there's in New Hampshire, our Constitution protects the right to worship and practice your religion. And if there is surgery and health practices that your imam or your priest or whatever could do, and it's provided by your church or whatever it is, you have the right to do that here in New Hampshire, and also to provide that to your if you're a priest, of some sort, and you want to practice. Like for me, I'm Taoist, so if I wanted to practice acupuncture, I could do that without a license.
I like your comments, by the way. Yeah, some of your comments that I saw was good. Anyway, so does anybody have any questions? Because it's about an hour now.
Yeah, if you guys got questions, put them in all caps if possible. It makes them easier to see. And Bear will try to answer them for you.
They will
But yeah,
try to respond, because the word answer, believe it or not, means
it's legal.
the pleading from a defendant, right? So
Right, right.
we
Okay, yeah.
don't we respond. Yeah.
We respond. So this is where the spellcast, see how crazy this spellcasting is. And
Yeah.
you have to decide whether you're going to worship Satan and participate in that, or if you're going to, be a white magician and walk in the light of the Constitution. So we got
How
one from Brad.
all right. Yeah.
How specifically might the
Okay.
Bruin decision bolster your arguments?
Well, for one, we found a law from 1786, which is our right to keep arms for personal use, along with our personal effects. Okay, so that's very very strong. By the way, Bruin is just a strengthening of DC versus Heller, and in Bruin we're talking about the text and tradition, um, about the text and tradition of the application of laws that pertain to the Second Amendment. By the way, which there are none. There are no laws that pertain to the Second Amendment. It always has to do with carrying and firearms and possession and so forth. Okay, but more importantly, what Bruin does, and I don't have the text in front of me, is it establishes a presumption. It establishes that the presumption that the Second Amendment is a proper act to follow. Because what the liberals and what all the gun grabbers have been saying when they quote Heller is that they'll quote that the government has never been not allowed to regulate firearms and all this stuff. And so again, I need the text in front of me to get it right. But basically, if you read it, it's something like the if conduct is within the Second Amendment, then the government must come up with some law that is a historical analog, which would be which should be comparable to the present regulation, which establishes the conduct as presumptively lawful. So Bruin is important in the due process sense because it shifts the burden of proof to the prosecution. Okay, I think that's not the best answer, but it is one that I've got for now, and we'll
And
try to answer more if
no, that's good. And we can always do follow up as well. We have a couple other questions. Sorry, I missed that earlier one. Anna Banana Rama, Anna Banana Republic says, what is the why do states call it constitutional carry? And then before you answer that, Rob wanted us to talk about qualified immunity. I think that could be a whole nother show.
Yeah. Oh,
And
yeah.
that would be definitely, if you're interested in talking about the qualified immunity stuff, I'd love to do that with you.
So I don't know much about qualified immunity. It's been a long time since I studied it, but I do know, like, the general idea. But let me tell you this: if you're thinking about qualified immunity, you're probably thinking about a suit under 42/1983. Am I right? Because most people have to delve into that subject matter in order to sue them for a deprivation of rights under color of law. And I'll tell you why those lawsuits almost uniformly fail. Those lawsuits uniformly fail because there's no declaratory judgment beforehand to precisely determine what carry a firearm means and what, for example, traveling means and what driving means and so forth. Before you get to your 1983 deprivation of rights, you need to do a 2201 declaratory judgment. And you need to define the law in such terms that the right is what they call clearly established. Otherwise, you're going to lose. Is that good enough for now? Anyway,
Yeah, I think that's really good. And I would throw the link in here for people who want to engage in our Telegram group. You go to absolutedefiance.square.site and go click on join the Lions Den. It is $5 a month. Just so you know, it's less than 20 cents a day. That's really just to keep the trolls out. It also is an easy way to support me and get in the group. Bear is in there. We have a bunch of other people in there. We're going to have more of these featured guests. And this is a great place. We have it broken down state by state, and I'll help with legal analysis. Bear will do whatever he can, but I'm going to be in there all the time. And we're doing the right to travel, constitutional law, using our words properly. What else is in there, Bear? Because you've seen the group, and what do you think about it?
one second here. Yeah, so Defiance group?
No, the Lion's Den one.
The Lion's Den. Here it goes. Yeah. So the Lion's Den. Yeah. So there's Constitution. There's the main chat center, inspiration, giveaways, holistic health, right to travel, legislative ideas, family court, which is a mess, secession, uh, New Hampshire, Kansas, DCF, DCYF, UK, Canada, FOIA, right, Freedom of Information, Second Amendment, which is basically what we're talking about, cop blocking, First Amendment auditing, religious discussions, politics, Massachusetts, join the White Rose, cameras in court, lawful tax avoidance. By the way, that's the other topic I'm fairly studied up on is how to get out of the federal income tax. But again, that's a completely different ball of
Another
wax.
show book. People should go to your channel. No Duty to Submit. Again, go to No Duty to Submit YouTube, and you could probably watch all his videos in a couple hours. And the tax stuff is amazing. I went to one of your tax presentations and recorded it a while ago, and I thought that was amazing, very informative. There was a wonderful question and answer session at the end of that. But you guys can get all the meat and potatoes at No Duty to Submit YouTube channel.
All right. Appreciate that, Frank. Thank you.
Yeah, no problem, bro. We got to get you. We got to get you to 1,000 subs at least, because then you can do your own live streams and stuff like that. So let's get him up there to 1,000 subs. Please go share his channel, share his videos. Like just that one, my Glock is not a firearm, is like share that everywhere. And get him up to 1,000 subs. Let's do this.
All right, man. Well, thanks very much, Frank. Sign off for now. It's been a real
Thank you,
pleasure.
Bear. And yeah, I'll see you in the group. And hopefully we'll have another one of these wonderful sessions explaining how to incant the right spells and become a magician, a legal magician.
Got it. All right. Thanks, Frank. Take care.
Cool.
Yep.
See you later.
Later.
All right, everybody. We're going to be signing off now. So thank you all for joining the discussion. And oh, it's 100 subs now? I thought it was 1,000. But yeah, so thank you all for joining in on this discussion. Again, go to absolutedefiance.square.site and you'll see all the links on how to support my work and how to get into the Lion's Den private Telegram group where we're dealing with the right to travel and the lawful tax avoidance, the right to bear arms, and all that stuff. So thanks again. Signing off. Have a wonderful rest of your Sunday, and I'll see you when I see it. And